We're discussing the prorogation of Parliament and legal challenges that are being contemplated by some groups to challenge that decision to prorogue. One of the things that I'm really curious about is these groups are bringing a legal challenge, but frankly, I'm surprised that advice from the Prime Minister to the Crown is even justiciable, that it's even something that the courts can give an opinion on. Given what they're asking for is sort of political tea leaf reading.
Well, prorogation is a prerogative power, and the courts have traditionally been quite reluctant to intervene in exercises of prerogative power. Prorogation is no exception. But you are right to instinctively think this is not something that the courts ordinarily get involved in, because the decisions being made are discretionary and are based on highly political considerations, and as you've mentioned, even partisan considerations, which really courts should not be involved in adjudicating on. Um, Probably the target of this case in federal court is going to be the advice of the Prime Minister. It's however hard it is to attack the Prime Minister and discretion that they exercise, it's even harder and quite possibly non-justiciable in our system to attack anything the Governor General did. So I would expect the focus would be on the advice the Prime Minister gave, which the Governor General accepted, but not on her decision in and of itself.
Anything you want to add there?
I think overall, I take Paul's point, and I think it's correct. The tendency of Canadian courts has been to be deferential towards the prerogative and towards vice-regal discretion generally. We may be seeing a bit of change of that. We've seen some shift in recent years in light of the British case, but I think in this context, I don't see any reason to think that the courts would suddenly find something justiciable here where they haven't in the past.